Welcome to this training that is an overview of the care process and follows a client's journey through the CARE Act. Specifically, this training is for volunteer supporters, and the goal of this training is to help volunteer supporters feel prepared as they begin to support someone through the CARE Act process. So today we have two presenters with us. We have Deborah Rose, and Deborah Rose is a licensed clinical psychologist, and she has extensive experience working with social service agencies, behavioral health centers, care coordination, supported housing, and services for unhoused populations. And we also have Ann Hadrius, and Ann Hadrius is from the Judicial Council of California, and she's the supervising attorney for the Judicial Council Center for Family, Children, and the Courts. And prior to joining the Judicial Council staff, she represented individuals with disabilities, particularly psychiatric disabilities, in state and federal court, and worked on legislative policy. So a look at our agenda. We'll be going over a few things. So one, understanding an overview of the CARE Act, discuss the why and the what of the CARE Act, and briefly look at the overall process. And then we'll look at the different roles and introduction to the different roles involved in the CARE process. And then Anne will take us through the CARE Act civil court process and look at the different steps. And this process can feel overwhelming, but the goal is just for you to understand what they are. You don't have to track those, but just so you know how you can support the respondent through their care journey. And then let's take a look at the learning objectives for this module. So our goal is that by the end of this module, you will have an increased ability to describe the why behind the CARE Act, to distinguish the different roles in the care process, and then describe the overall legal process and some key components, and know how you could help support the respondent. So with that, I'm going to turn the time over to Deborah Rose to start into this overall discussion of the why behind the CARE Act. Deborah?
Thank you, Patricia. It's good to see you. Thank you for having me. And hi, Anne. It's good to be here. We'd like to begin talking a little bit about the why behind the CARE Act, to contextualize it and to put it into context of how the CARE Act came to be and what it's intended to do. In California, nearly 1,300,000 people are living with a mental illness. And of those folks in California, about half of them aren't accessing behavioral health services. So that means there's a pretty big gap between those folks who are living with mental illness and those folks who are getting services. And that gap has implications for all of us. For the individual who's living with a mental illness who's not receiving services, that gap really can mean the likelihood and the potential of unemployment, of housing vulnerability, of homelessness, of hospitalizations, of interactions with the police or other law enforcement, in incarceration, and general poor health and overall poor quality of health. And so the goal of the CARE Act is to provide services before these things occur, to provide services on the upstream before people are hospitalized or interacting with the criminal justice system, before they end up in conservatorship or in a justice setting. So really the idea of the CARE Act, the whole crux of the services to promote overall care, access to services, access to housing in the community where people live and function. We've included some links throughout the course of this presentation, but in particular on this one, if you'd like more information, there's a link at the bottom of NAMI, the National Alliance of Mental Health, and it'll give you some additional information. So let's talk a little bit about what the CARE Act does, what it's designed to do, and how it can have an impact on our community. The CARE Act creates a new pathway, a new venue to deliver mental health services, and substance use services, treatments, recovery supports for individuals who are living with untreated schizophrenia, untreated schizophrenic spectrum disorders, or untreated psychotic disorders. The CARE Act allows the court to order the county to provide behavioral health services in a community setting. That means that the CARE Act holds the county accountable to provide services, not only the individual who's receiving services, but the county who's providing services. And when we look at this journey, this roadmap to access supportive services in the community, it really begins with the individual who's entering this pathway when the petitioner requests court involvement for the purposes of the CARE Act or a care agreement. In this case, the person is entering it at the time of the petition when the petitioner is asking for court-ordered treatment, recovery supports, and housing resources under the CARE Act for eligible participants. Let's talk a little bit about the CARE Act, an overview at a glance. And this is going to be a very high level overview. You'll see a picture of Michael. He's an individual that we'll reference throughout this discussion, and we'll get into a lot more detail about Michael later on. Michael is a fictional character. He's going to seem familiar to a lot of us who have worked in these areas for a long time, but he really is a conglomeration of different aspects of individuals. So he is somebody that we made up who may be very common when we look at CARE Act services. Looking at this overview of the CARE Act at a glance, there are a number of ways that people can enter into the care system of support. There are a number of paths into this. There are several potential people who can start the process, who can initiate the request for CARE Act services for individuals who are living, again, with untreated schizophrenia, untreated schizophrenic spectrum disorders, or other untreated psychotic disorders. And those are folks who may be eligible for services. And the folks who can petition the court include family members, very specifically parents, spouses, siblings, children, or grandparents. Petitioners can include a county health provider. It can include the county mental health department. It can include first responders like a police officer, an EMS worker, and it might include social service providers. And so these are folks who are offering supports in the community and who know the recipient or the respondent. Again, respondent is a legal term. I'll sometimes bounce back and forth between client, respondent, individual, person. As we move forward a little bit past the petition into the care process itself, and I've gone now from the orange to the turquoise on the screen, the care process is a civil court process. It's not a criminal court proceeding. It's a civil court process that really is designed to connect folks to care and to prioritize services, to prioritize treatment, to prioritize housing for those individuals who might benefit from CARE Act proceedings. As we move towards the blue, there are a number of paths out of the care process. A couple of examples is very early on, the Behavioral Health Agency in a county may attempt to engage an individual who we believe to benefit from these services. It may be possible that the individual is eager to engage in services and is accepting the referrals, and that person may be diverted out of the CARE Act proceedings through engagement, through an agreement. Other ways that somebody may pass through the care process includes graduation from a care agreement or graduation from a care plan. Quick note, the right side of your screen, the very dark blue, the navy blue, is we do want to point out that care and support, recovery services, housing, medication, care coordination, all of that package of services that are designed to help individuals succeed successfully in the community should continue when the CARE Act order itself ends. So this really is about creating services, providing services, and then continuing the services to help people live independently in the community.
As was mentioned earlier, I'm an attorney and I work with the Judicial Council of California. And this slide here kind of lays out the court process. And big thank you to the LA court system who came up with the original version of this graphic. There's a lot of pieces going on here, and later on we're going to go into more detail on each of the steps. But for right now, just kind of wanted you to see the whole picture, which starts with, as Deborah was saying, an initial petition. And initial steps to engage the individual who in the court process is called a respondent. And depending on what happens with that, it may move into additional court processes and additional hearings. That's the blue section in the middle. And then moving on to additional service delivery and moving forward for next steps, which is the last piece in teal. But as I said, we will be going through this in much more detail later on, but this gives you kind of a roadmap for what the care process looks like from the court's point of view. So, thank you, Deborah.
Thank you, Anne. Looking forward to hearing you talk about all of those in details and learning a little bit more. We'd like to jump into an overview of some of the roles that you may see for people who are involved in the CARE Act. And these are the primary roles that we're going to talk about. We'll talk about the respondent or the client. Let's also talk about the petitioner. We're going to discuss the volunteer supporter. Sometimes you'll hear that person referred to as a volunteer supporter or a supporter. We'll talk a little bit about the County Behavioral Health Agency, what kind of housing and community support providers might be involved, and lastly, the court system. And I'm going to ask Anne to jump in there and talk a little bit about some of the players who are involved in the court system. So why don't we talk about the client or the respondent, the individual who's living with a mental health issue who might benefit from CARE Act services. And again, you see Michael. We will talk about Michael in detail. We're just setting the stage for what services and what CARE Act for Michael might look like. The first role that we really want to get into, as I mentioned, is the client or the respondent, the person who is receiving services. Respondent is a legal term. Again, sometimes I'll say, I'll refer to Michael, or a client, an individual, a person who's living with mental illness. Often you'll hear the term respondent used depending on who's talking about the person who's receiving services. So this slide gives a really high-level overview of the eligibility for people who might end up in a client or respondent role. Potential clients and potential respondents for people for the CARE Act are adults who are ages 18 years and older. And these are adults who are living with a diagnosis of schizophrenia spectrum disorders, or of other psychotic disorders. And these are individuals whose symptoms are pretty significant, and they've been severe in length, in the expression of symptoms, in the duration of symptoms. And so this may have very real implications in daily functioning, and it can impair things like the ability to adjust to situations, the ability to maintain a stable living environment. It can impair one's ability to maintain relationships in the community with family, to hold down a job, to function independently, and really that kind of functioning where somebody's not at their best are things that we might look for when considering who would benefit from CARE Act involvement. The client are people, or the clients are folks who are not stabilized with ongoing voluntary services. They tend to be people who have rejected traditional kinds of services, who might have rejected clinic-based care or ACT teams, FSP teams. And these are individuals who are unlikely to survive safely in the community or live independently without those additional wraparound services to help folks thrive independently. And these are folks that perhaps we're seeing that there's ongoing deterioration in one's functioning and condition, and exacerbation of symptoms based on all of these challenges within the living environment. What's really important to note is that the participation in the CARE Act is the least restrictive environment. The idea of providing care services, it's community-based. It's getting care where a person lives, where they feel connected to a community, and it's really designed to be an alternate to other more restrictive avenues like LPS or incarceration or conservatorship or other kinds of interventions. So again, the client is the person who's living with a significant mental illness in the form of schizophrenia or psychotic-like disorders, and this person is likely to benefit from services because they'll be connected to lots of wraparound, person-centered, recovery-focused services to help create and support independence in the community. In the next section, we're going to talk a little bit more about Michael as our client, and we'll refer back to Michael and his family and some of those other some of those other provider roles that we've talked about earlier. For more information, again, there's some links at the bottom of the screen. You could take a look at the CARE Act eligibility criteria, and you can also look at training materials for eligibility and practice. Let's move on to the petitioner. So petitioner, a legal term, is really the person who is helping to bring forward the requests and the motions for a CARE Act. This presentation is designed for voluntary supporters. And so the supporter, while maybe is involved from the beginning in the person's life and may have a long history with the client, it's also possible that the supporter is first coming in after the petition has been filed. We expect that there's going to be some commonality to who the petitioners are, but petitioners aren't limited to just what we think is going to happen. There's a list of eligible participators, and I'm going to go through them kind of quickly so that we understand who has the authority and the weight to bring a petition forward. First, as a petitioner could be an individual with a legal responsibility that is equivalent to a parent or parental role. Other family members might also be petitioners. This could be a spouse, a sibling, it could be a child or a grandparent, but family members right now are limited to those roles, and those are listed on the slide. You can reference them later. A petitioner could be a mental health professional or a service provider that has recently or is currently working with the individual and has provided treatment in the course of the individual's recent experience. The petitioner could be the director of a hospital, his or her designee, and that would be a hospital in which the person was recently or is currently hospitalized. There's lots of different public service agencies like the County Behavioral Health Agency or Adult Protective Services. It could be directors of these agencies or their designees who serve as petitioners. Also, a petitioner could be a first responder who's had lots of contact with the individual. And this could be a firefighter, a police officer, an EMS worker. It could be a mobile crisis worker, somebody who's made constant outreach efforts to engage the individual in care. And we do expect to see some homeless outreach workers who are familiar with folks like Michael living in the community who might serve as petitioner. Petitioner can also be a roommate or somebody with which the client resides. And then last, and I think this is really important, is that a petitioner can be the client themselves. I may be somebody who wants to access services, who is seeing this as an inroad to obtain care, to find housing, to get the kind of supports that might have been challenging otherwise. And so an individual, Michael, could choose to serve as a petitioner or request a petitioner on his behalf in order to access some of these services. There is an entire list that's available to you, and you can find that. Again, we've included a couple of links. And so if you want to see the entire list, please go take a look at those at another time. Let's move on to the volunteer supporter. This is a pivotal role throughout the CARE Act and throughout care proceedings. Sometimes I might refer to it as a volunteer supporter or supporter. You'll hear both. Because there's a recognition that the supporter is an essential component, there's going to be lots of training, lots of technical assistance, and lots of supports for people who are in supporter roles. The volunteer supporter is a person who's selected by the client. This could be a natural support, a family member, a person with lived experience of substance use, behavioral health recovery. Really, the supporter is a person who is there to assist, who is there to uplift, who is there to advocate for the individual who is experiencing and going through the care proceedings. And the volunteer supporter is an individual that respects the client's preferences, their rights, their wishes, their beliefs, their goals, their dreams, trying to include all of that in a person-centered approach so that folks are engaged in the care proceeding and that the individual's voice is heard. The supporter really helps support the individual's autonomy and independence and decision-making throughout these proceedings. Again, so that CARE Act respondent, his or her wishes, desires, preferences are recognized throughout the CARE Act proceedings. This person may be part of the care plan itself and can continue to provide ongoing supports throughout the CARE Act initiation and ongoing post-graduation or post-dismissal. So there's additional resources for you. We've put some links into the bottom of the slide. Support a role in a CARE Act brief, which is a go-to handy cheat sheet that you can use, and a support a role in the CARE Act, some additional training materials. Another role that is essential to talk about is the County Behavioral Health Agency. And so this is the agency that's assigned to engage with the client as they enter the pathways or they begin the CARE Act agreement or care plan. We talk about engagement in the beginning, but engagement, ongoing engagement, is really essential throughout the entire course of care, because it's that engagement that is going to help an individual connect, understand, believe in, agree to, be willing to consider the services that are offered. And so engagement doesn't begin and end with a petition. Engagement continues just throughout the lifespan of our involvement with people who are part of this process. The County Behavioral Health Agency will look different in each county. And so rather than getting into each of them, just to help understand that the County Behavioral Health Agency might engage some of their professionals who are within their in their county to do some outreach and to provide services. And these might include assertive community treatment teams or ACT teams. These are like clinic on wheels that support individuals in the community. There are also some similar wraparound teams like full service partnerships or FSPs. Both FSPs and ACTs, ACT teams, maintain fidelity to a very prescriptive approach. It's a model, like I said, a clinic on wheels. It's a group of professionals who work with a small group or small census of individuals and provide very intensive community-based services to folks, regardless of the environment. Maybe they follow an individual into a home, into a shelter, into the street, and meet with the individual and offer very concrete and ongoing services throughout the course of care. And really, the goal is to help and support individuals to develop and build and sustain autonomy and self-care skills so that somebody can live successfully in the community, in recovery, in their definition of recovery, with some autonomy until they're ready to transition to a lower level of care. So again, the behavioral health agencies per counties are going to look different in each county, but regardless, they will play a key role in providing outreach, creating the initial petition, creating an initial report, conducting a clinical evaluation to determine if somebody is likely to meet criteria for the CARE Act, and they will engage the individual in mental health recovery services and in supports, including housing. For additional information, we've included a link here as well, and you can find that at the bottom of your screen. A critical aspect to the CARE Act is the prioritization and the connection to housing and community supports for individuals and for respondents of the CARE Act. There's lots of different potential housing types in California, and they'll likely be different for each individual. A couple that we may see most often on some overview, a high-level overview of the various community-based housing models might look like the following. There's permanent supportive housing where people can live with ongoing on-site supports that might include benefits, training, social services, psychiatric, behavioral health. There's transitional housing for folks who can have some very intensive experiences as then they are transitioned onto less intensive housing. And we'll hear about behavioral health bridge housing, which really is sort of the gold standard and the model that we're looking to see, which is prioritized for people who have a care agreement or a CARE Act. There are additional community supports that offer social service and housing, depending on social security income, depending on financial assistance, depending on CalWorks, and there's other kinds of supports that will be made available, including nutrition, nursing, and in-home supports. If you look at WIC 5982, there's a number of housing programs, there's a number of financial sources, there are a number of community supports that are listed. Again, we wanted to just identify that the call out here is that individuals who are engaged in the CARE Act proceedings should be prioritized for any appropriate bridge housing that's funded through the bridge housing program. There's more to come on this, and for some additional information, at the bottom of your screen are a couple of links on the CARE Act fact sheet and on, excuse me, the California WIC code. And so we're going to move on to some of the judicial and legal roles, and I'm going to ask Anne and pass it off. If you can take over, please.
Yeah, no problem. Thank you, Deborah. So as Deborah mentioned, this is a legal process and there are legal components. So there are legal players that it's helpful to know and understand. In CARE Act proceedings, there's generally going to be counsel for both of the two main parties. So the first is behavioral health. We'll get to it in a minute, but after the initial court hearing, behavioral health will take over as the petitioner. And so they're usually represented by their county counsel or another designated attorney. And the respondent in the statute specifically has the right to court-appointed representation for the entire process at all stages of the proceedings. And that's regardless of their ability to pay. So there's no determination. They don't have to be indigent. They will get court-appointed counsel. And that is going to be either a qualified legal services provider, generally called a legal aid provider, or the public defender. And their role is to represent the respondent's interests and rights and to protect the due process for their client, who's the respondent. And then last but not least, there is a judge or a judicial officer. Their role is to be a neutral arbiter. They're listening to both sides, both to the petitioner and the respondent, and trying to find the best set of services and supports, if appropriate, for the respondent. The statute does lay out that unless there is a dispute of fact or law, so unless there's some kind of disagreement, the goal is to make the proceedings as informal and non-adversarial as possible. That said, if there is a dispute, it may become more of the kind of traditional courtroom picture that you may have in your minds. And then the last thing to note is that there's this idea called the black robe effect. The idea of a judge wearing a big black robe, even if they are not necessarily pushing as hard as they might in a different type of case. You know, this is a civil suit. It's not a criminal case. And even though the goal is to emphasize self-determination, a judge or judicial officer tends to add some weight and gravitas that can encourage adherence on the part of both parties. So we're going to talk about that later on, but there is provisions for accountability, both for the respondent and for county behavioral health. And as in the other slides, we do have some additional information in the links at the bottom. So if you want to get more understanding about the legal roles within the CARE Act, we encourage you to take a look at that brief that's linked there. Thanks, Deborah.
Thank you, Anne. So I'm going to just take a quick moment to highlight some of the roles that we've just talked about. 6 roles: the client or the respondent. Again, this is the individual who's been identified as a potential recipient for CARE Act services, the petitioner who's bringing forward these motions, the volunteer supporter or supporter, the county behavioral health agency, the housing and community supports, and then finally the court system, legal individuals. And there's a lot of folks involved in this. So what we'd like to do is just ask you to take a moment, maybe on a scrap piece of paper, in a notebook, or on a Word document, is to take a look at some of those roles and make a note of where you have questions, where you'd like additional clarification, where you'd like to learn more. And have additional training. So after you do that, please consider sharing your questions with the case manager at the Behavioral Health Agency, or you can email info@care-act.org. I'll say that again, info@care-act.org with some questions. In this case, again, questions if you have about the particular roles, or what that individual in the role can do to support a person who has been identified for CARE Act proceedings. Let's move forward and talk about the journey through the CARE Act. I've made a few references to Michael earlier, and I'm going to talk about Michael a little bit further. As a reminder, Michael is not a real person. This is a hypothetical individual that's been made up of characteristics from people that I and other professionals have worked with over the years. And so any resemblance to an actual person is strictly coincidental. So given that we have talked a lot about roles and proceedings and professional positions, we really want to bring it back to the individual, the perspective of the person who, again, is living with schizophrenia or schizoaffective disorder, other schizophrenic-like conditions, including other psychotic disorders, and what it might be like for that person to experience this process and what that person might look like. So to talk about Michael and to contextualize this a little bit, I'm going to give you some details. And then when I'm done, Anne is going to help us understand what Michael's experience might be like as he goes through the care process. So Michael is a 43-year-old male, and he was diagnosed with schizoaffective disorder after the age of 18. He had been living with his parents and had been attending school, but not long after his diagnosis, he dropped out of school. He maintained a couple of odd jobs while he was living at home, but eventually he lost his jobs. He left home and ultimately ended up homeless. While he was living at home and earlier on, before he started experiencing some of the symptoms of schizoaffective disorder, he had been close with his parents, Brian and Sarah. But as the illness became more significant, he became less trusting of his parents, less trusting of other people in general, and began to have difficult times in the relationships with his friends and families and people who were around him, particularly with his parents. They wanted to support him. They encouraged him to accept supported housing. They offered to provide kinds of housing supports for him to stay at home and to live at home with services, which he declined those opportunities. He ended up living in a homeless encampment, not far from where he grew up. And Brian and Sarah did the best that they could to keep track of him, but he really declined involvement with them and declined an ongoing relationship. He's been hospitalized a number of times for behavioral health related conditions, and 2 times in the last 2 months. In each of these hospitalizations, he was discharged after a brief hold. He quickly learned that if he was able to say yes to meds and accept meds and agree to meds in the community, then he would be given a prescription and discharged. So he wasn't in the hospital for very long. Now, if we see Michael, he seems internally preoccupied. He seems to be hearing voices that other people don't hear. He's losing weight. It seems like he's tired. He's sleeping a lot. He's not at a place where there's a medical emergency, or there doesn't seem to be the need for medical intervention for the weight loss or the sleep excess sleep, but it is noticeable, and other people are noticing that he seems thin and gaunt and tired. There's been, in the last couple of years, a number of times where he was placed on a WIC 5150 for grave disability. But again, he's been brought to the hospital, provided medication, stabilized, and then was quickly discharged. He's frequently been given prescriptions for antipsychotics, and he generally doesn't fill them once he's in the community for a couple of days. Now, Michael is living in a housing encampment. He's not far from a soup kitchen, and he does go to the soup kitchen every day for a meal. And when he's there, he sometimes seems distrusting of people who are around him, including the workers at the soup kitchen. He's had a couple of fights, verbal altercations with both staff there, with volunteers there, and with other folks who are receiving services and receiving assistance at the food kitchen. A few times police have been called. There hasn't been any interaction. He leaves, and then he comes back the next day, and where his behavior is a little bit unpredictable and erratic. Because they've been tracking and trying to keep an eye on Michael, his parents have made lots of efforts to engage him and to utilize the services and system that's been designed to support him. And so they've contacted the homeless outreach team. And these are folks who are trained to work with folks who may be housing vulnerable, homeless, living on the streets. And the housing outreach team has made a number of efforts to go out and engage with Michael. But he's been hesitant to receive services, and he declines them. So again, we're going to use this description of Michael to talk a little bit more in detail about what it might mean to support Michael and then to support him through the role. Quick reminder, Michael is a fictional character that we just made up. So as a supporter, as a voluntary supporter, a volunteer supporter, what does it mean to assist Michael in this process? And before going into the court process, I want to really think about a couple of things that might matter. Although we're going to be talking about court dates and timelines, I don't think it's important that you know all of the dates. I think it's important for supporters to understand the process. Things can be written down. It's really about understanding how to help Michael through the proceedings. And I think that the opportunities to do so is putting on that trauma-informed, thinking about what Michael's experience has been like, using a person-centered approach. Michael's an individual, again, who's got strengths, who's got goals, who has hopes, who has dreams. He's not somebody who's just living in a homeless encampment. He's somebody who's got lots of value to the role that he contributes to his family and the community as well. So thinking about Michael and what's important to him and his preferences and his needs and how to help express Michael's voice and to help Michael express his voice, there are a couple of opportunities. Some of it might be helping Michael to understand the CARE Act and the CARE proceedings, explaining what that looks like, talking to him about the different roles, helping him understand where he might be going, who the people look like, where the environment is that he might be participating. How is he getting there? Who would he like to participate with him? Who else would he like to be present with him? It might be talking about what kinds of treatment options, recovery options, housing options, support options are available to Michael through the CARE Act. It may be helping him understand choices and options that he has, whether it's medication, again, housing, or other support services that he may have preference for particular services over others. It's really about serving as an individual who can help Michael to express his preferences, needs, wishes, and to be a neutral person who can advocate for those on behalf of Michael as well. I think it's worth encouraging the supporter to create a plan to support Michael. And this might mean weekly contacts, where you might meet, where the supporter might meet Michael, more frequent contact, how to reach each other, to give a phone number or contact. And those plans can be revisited and should be revisited often throughout the care proceedings. Like some of our other slides, we have a number of links that are at the bottom. If you'd like to take some time to learn more about the supporter role, there's a brief that's available to you, and then there's also some training material. I'm going to turn it over to Anne, who's going to talk a little bit about what Michael's experience might be as he goes through the care journey. Anne?
Thanks, Deborah. So, as Deborah was mentioning, it's not the supporter's role to keep track of all of the court hearings, but the respondent, in this case, Michael, does have the ability to bring a supporter with him to any of these hearings or any of these meetings. And part of the supporter's role is helping Michael understand what's happening here, and so that he can express his preferences, and helping Michael express what he's looking for. So having a little bit of background on what the court process involves is helpful, even though there's no expectation that a supporter needs to be a legal person or needs to understand all the minutiae. But we do want to go through it in a little more detail than I talked about before, walking through the initiation and engagement, the court process and service connection, and the service delivery and next steps. But I do think it's important that everyone keep in mind that the engagement between Michael and County Behavioral Health that we're particularly talking about at the beginning, and we've said this before, but it's really important, that's a process that should be continuing throughout through all of the colors on the journey. So, as we said, it starts with the petition. All care proceedings must start with a petition, and it can be filed by any one of the enumerated potential petitioners that Deborah listed, including certain family members, behavioral health providers, first responders, social service providers, hospital directors, etc. In Michael's case, it's going to be his parents, Brian and Sarah. And what they're going to do is they're going to fill out a petition, and they're going to take it to the court. They have the ability to get additional help with that by going to what's called a court self-help center, where they can get assistance filling out the paperwork. And Brian and Sarah decide to do that. They fill out the petition, they attach the required information, and they file it with the court. The first step, the court will look at the petition and make a determination about what's called prima facie. So that's a first look on its face. Does the petition provide enough information to show that Michael is or may be a person who meets all of the criteria for the CARE Act? So does he have a qualifying diagnosis? In this case, he does. He has schizoaffective disorder. Does he have, is he potentially at risk for surviving safely? Not necessarily. He has been assaulted and he's needing to use the soup kitchen, but not doing it as often. Is his condition deteriorating? Yes, he appears to be more preoccupied. He's been losing weight. These are the things that the court would look at in the initial petition. And if they find that there is enough there, they will order a county agency, often County Behavioral Health, to do a report. And so what happens here is that agency will go out and meet with Michael, and they're required to put a few different things into the report that comes back to the court. So one of them is, based on the county agency's expertise, do they think that Michael meets the criteria? So For example, if they go out and find out that he actually doesn't have an eligible diagnosis, they would put that in the report. In this case, he does. So they would go through and note whether, in their opinion, they thought he meets the criteria. And then the second piece is the county will make an effort to voluntarily engage Michael in services. Ideally, what the parties would like would be a voluntary agreement. And so if Michael is willing to accept services voluntarily and likely to do so, that will go into the report as well. And if so, the care case is dismissed. The care process ends there. The same with if the county finds that Michael doesn't meet criteria for whatever reason. In either case, the court would end the case right there. But in Michael's case, neither of those things happened. So the court reviews the report. They find that he may meet the criteria and he's unwilling to voluntarily engage. So the next step is the more traditional court process. All right, now we're going to move into the court process service connection section of the care process. And this is a lot of the kind of intensive court piece. So we're going to walk through each of those. In this case, so at the report, Michael was found eligible. He declined to voluntarily engage. So the court will set what's called an initial appearance. The initial appearance is the first time that the parties are going to come to court. Now, as I said, it's not necessary that a supporter would need to know each of these steps, but it is helpful to understand and be able to support the individual, in this case, Michael. And on the next slide, we'll go a little bit more in depth into each of these specific hearings. So the first one is the initial appearance, as the name implies. So that's the first time the parties are going to be in court. Counsel for the respondent, for Michael, will be there. Respondent Michael will have the opportunity to say that he wants to have a supporter. And if he wants, he can bring that supporter to this hearing. So in this case, he's choosing his mother, Sarah, to be a supporter, and he lets the court know that. At this first initial appearance, the original petitioners, Brian and Sarah, have to be there or the case can be dismissed. The Behavioral Health Agency also must be there. And as I mentioned earlier, this is where the court will sort of swap out the parties. So Brian and Sarah will no longer be the petitioner. Now County Behavioral Health will be the petitioner. But Michael has decided to have Sarah, his mom, be the supporter, and he lets everyone know that. The initial appearance can be held concurrently, so at the same time as the hearing on the merits, but it doesn't have to be. And let's talk a little bit more about the hearing on the merits. So the hearing on the merits is an evidentiary hearing where the court will decide if there is clear and convincing evidence that Michael meets the CARE Act criteria. Because if the court doesn't find that, then the case will be dismissed. So in both parties, both County Behavioral Health and the respondent, Michael, have the right to present evidence, to call witnesses, to make their case. And Brian and Sarah, as the original petitioners, have the right to make a statement. At the end of the hearing, the court makes its decision. And in this case, the court finds that Michael does meet the criteria by clear and convincing evidence. And so the next step is to order the parties, particularly County Behavioral Health and Michael, along with his supporter, if he wants, Sarah, and his attorney, to work on a care agreement and determining if they can create a care agreement. So all those parties come together. Hopefully they come to an agreement that lays out the service and supports that Michael would receive from the county. And if they are able to do that, that would be included in a written voluntary settlement agreement, which would be brought to the court. However, if they are not able to do that, we move forward in the process. But what happens next is called a case management hearing. And this is where the court will determine whether there is an agreement, or whether it's likely that they'll be able to make an agreement. If they have reached an agreement, the court can modify it. It actually has the ability to change it. And then we'll approve it. And there's a little arrow here going to the right, going to a progress review hearing, which is the next step for folks who have a care agreement. However, if they are not able to agree, then we move on to the next step in the process, which is the clinical evaluation and hearing. And in this example, they tried to make an agreement, but Michael didn't agree because it included medication. And he didn't like the housing provisions that were included. So the court found that they were not going to enter an agreement. And it ordered County Behavioral Health to do a clinical evaluation of Michael to determine a couple of things. One is, does he still meet the diagnostic criteria that are in the CARE Act? But also looking at questions like capacity for medication and medical decision-making, particularly capacity to give informed consent regarding psychotropic medications. And it must include recommendations for services and supports that it thinks the court should use. So based on that evaluation, plus any other additional information that the parties want to provide, the court will make another determination. Again, deciding by clear and convincing evidence whether Michael still meets the criteria. And in this case, the court reviews it and it finds that he does continue to meet the criteria. So it orders Michael and County Behavioral Health with Sarah on Michael's consent and with their attorneys to try to create a care plan. And that gets us to the next step. So the parties attempt to create a care plan. Ideally, they would agree on one plan, but that's not required. It is possible that they would create two different plans or more than two different plans. But they will bring those plans to the court at the care plan review hearing. And then it'll be up to the court to look at what makes the most sense for Michael and would be the best for his stability and recovery. So as I say, there could be two different plans. The court can choose either one, or it can choose parts of one and parts of another. So it considers and adopts the elements of the plans that best support his recovery and stability. And this is where the court has the ability to issue additional orders, such as prioritization of services that will assist Michael in accessing the services. It's worth noting there's a specific issues around medication. The statute lays out that for medication to be included in the care plan, the court must find that Michael lacks capacity to give informed consent. Otherwise, it cannot be included in the care plan, although there's no reason that County Behavioral Health cannot offer additional services than the ones that are included in the care plan. But additionally, even if that lack of ability to give informed consent is found, it's not an involuntary medication order in the sense that medication may not be forcibly administered. And as we'll talk about again a little bit later, there is no penalty if Michael declines to take the medication, even if it is included in the care plan. All right, so the court has put together a care plan, ordered a care plan that has all of the best elements for Michael. And now it's going to go through, now it's going to be reviewed. So ideally, now is where the county and the respondent are working together to get him connected to the services, to deliver the services. And then every couple of months, at least every couple of months, it can be more often, they can be brought back for status review hearings. And those will continue for up to 1 year. As I said, no less often than every 60 days over the life of the plan. And at the end of the year, a few different things can happen. 3 in particular. 1, Michael can decide that he wants to graduate. So what that means is, he's doing well, he's working well with the county, they create a graduation plan so that services continue, and there's actually a graduation hearing. So that's the arrow going up on the little diagram. Option 2 is Michael can decide that he wants to stay in care. It's going pretty well, but he hasn't fully completed everything in the plan, and he wants to keep doing that. And then the court may choose to permit him to stay in the plan. And then we start again with status review hearings and hopefully moving to graduation. And then there is a third option, which is involuntary reappointment. And that can only be for 1 year and only under very specific conditions. And again, would result in additional status review hearings up to a maximum of 1 additional year. And now I'm going to turn it back to Deborah to talk to us about some of the practicalities about what happens if Michael doesn't want to participate, even after all of these steps.
Thanks, Anne. Even after all of these steps, and even after outreach and engagement and ongoing engagement, it's possible that Michael chooses not to engage in services that have been identified for him. So it's important to remember that if Michael or any client chooses not to participate in the services, this is a civil court order. It's not a criminal court case. So if the individual chooses not to participate or engage in services, there's no criminal consequences. The person will not suddenly have a parole officer or probation officer, be referred to the police. There will be no charges that are made. There is still opportunities, though, and I think it's really important that the supporters recognize those opportunities to continue to provide guidance, to mentorship, coaching, support, direction to the individual who declines care services. In the case of Michael, it may mean continuing to meet with Michael in the community. It may mean trying to help him identify and articulate what his preferences are, what his wishes are. It may mean revisiting some of the services to look at amendments. It's really about supporting the individual's autonomy and the right to self-determination throughout the process, whether the individual is assenting or declining services. Supporters certainly can continue to encourage Michael or the recipient to engage in community services. Perhaps there are drop-in programs or self-help groups, peer recovery supports. And so despite one's involvement or lack of involvement, there's still the opportunity to continue to try to support an individual to access services that may interest the person. We want to, again, talk about the opportunities for the supporter to receive training, to receive support. There's a number of resources that have been identified throughout the slides. A couple of areas that we think might be really essential: training in mental health and mental illness. What do we understand about how people think, function, behave, interact? What do we understand about the diagnosis? What about co-occurring medical behavioral health conditions or co-occurring substance use behavioral health conditions? What kind of recovery options and treatment options may be available? What kind of evidence-based services? These are programs and pathways that have been recognized and have proven to have an impact on people who are living with mental illness. Opportunities for training on trauma-informed care, recognizing that supporters will be working with individuals who have experienced trauma in their life. Maybe trauma early on, perhaps trauma as a result of the mental illness, perhaps trauma as a result of one's living conditions. But so having a trauma-informed lens to engage the person, I think, will be really relevant in that successful relationship. And then you'll hear about, we'll talk a lot in other trainings about motivational interviewing, sometimes referred to as MI. And motivational interviewing is a technique and a tool that's really used to help practice active listening and asking open-ended questions to try to understand the individual better and to try to encourage a position where one can make gradual changes and accept and move in a direction towards a journey of recovery through mental illness and substance use. So there are a number of opportunities and a number of trainings that will be available on the website, and we certainly encourage you to participate in many of those trainings. I am going to return this to Anne, who I think is going to drive us home.
Yeah, so we talked about earlier that one of the things about the care process is accountability, and that there's accountability both for Michael and for the county. And although there cannot be criminal accountability, there is accountability within the civil system. So there's a few kind of things that I want to highlight here. One is, at any point, if Michael is not participating, the court can terminate his participation. If he's not participating, is not following orders, can terminate. The other piece is that if Michael is on a care plan, which in this case he is, and the county behavioral health has provided all of the services in the care plan on a timely basis, and he is terminated from that plan, if he ends up in an LPS hearing, so like a 5250 hearing or a conservatorship hearing in the next 6 months, that termination will be informed to the court that's hearing that, with a presumption that Michael needs additional services and supports based on than what he had in the care plan. So that's one piece. But as we mentioned earlier, non-adherence to a medication order cannot have any penalty. So that includes termination. That includes, it can't be used against him in a future proceeding. So there is no penalty for non-adherence to a medication order, although it may affect other things in his care plan, for which there can be some accountability. And there is some confusion, so it should be pretty clear that although there are some similarities or connections between the care process and LPS proceedings, a termination from care does not automatically lead to LPS, does not automatically lead to a conservatorship. There's a standard for conservatorship, which is true regardless of whether Michael was in care or not, with the exception of this additional presumption if there is a hearing in the following 6 months after termination of the care plan. Now, if Michael does choose not to participate and is terminated, it's also worth noting that nothing stops County Behavioral Health or other community support providers to continue to outreach to Michael, to offer services, to work with him on a voluntary basis outside of the court system. It would just be separate from his CARE Act case. So that is Michael's accountability, but there's also accountability for the county where he's living. Really this is, I've been talking a lot about more of the court hearings and legal proceedings, but this is ideally an engagement and connection process. And even if Michael refuses some of the services, the county still needs to provide the services. And if the county is found to be violating orders that can create legal steps against the county if they do not provide the services that have been ordered by the court.
Anne has shared a lot of details about the CARE Act, CARE Court, CARE Agreement process, and there is a lot of information on this very beautiful slide, and we thank LA County for creating that. I again want to invite the listener to take a moment to look at what's on the screen and just jot down a couple questions that you might have, gaps in knowledge that you have. We talked earlier about jotting down questions about who the various players are, what roles there might be. Here I'm going to invite you to jot down a couple of questions that you have about aspects of the process that you might not understand or that you'd like to get additional information on. And after you jot that down, I certainly invite you to speak with the care manager in your county or the respondent's care manager, or please, respondent's legal counsel or behavioral health agency, or please feel welcome to email us at info@careact.org. And we'll say it again, info@care-act.org. And so I want to thank you for attending. Patricia, thank you for including me. I'm going to, and thank you, Anne, for all of this information. Patricia, I'm going to return it to you.
Thanks, Deborah, and thanks, Anne. So, we shared a lot of information about this court process, and as Anne mentioned, our objective isn't for you to keep track or know or drive the respondent's process, but just know how you can step in to help. So our goal is that by the end of this session, you would have an increased ability to understand why behind the CARE Act and what the goal of the CARE Act is, understand some of the key roles that will participate in that CARE Act process, and then have an understanding or be able to describe the overall legal process that Anne walked us through. And again, your role will likely be supporting the respondent, helping them prepare, helping them through supported decision-making conversations to better understand their needs and preferences, and helping prepare with the respondent. So on the next, we can see our website and our email address that Deborah mentioned. And please reach out to us if you have questions. We also have some additional resources. So there are a number of resources and places for you to turn to. We have informational videos, fact sheets, and we're adding to this list continuously. So please go to the CARE Act Resource Center and get information or reach out to us through that email address if you want support or help or navigation to the right people to connect with. So thanks for joining this training, and please reach out if you have questions.